our keynote speaker, Dr. Biren Saraf. I welcome you all for this commemorative function for the 10th Constitution Day that we are celebrating here. The senior advocates who are present here, Learned Deputy Solicitor General, the senior advocates, the students, and my fellow colleagues. Welcome you all. Now, when we talk about Constitution, normally our Constitution faces two criticisms. Well, the first criticism is that it's very lengthy. The second criticism is that there are too many amendments. There are 106 amendments as of now. I believe the answer to the second question lies in the first question. Since it's a lengthy Constitution, we require many amendments. When we talk about the lengthiness of the Constitution, and if you go through the Constitution, the simple question which we must answer is any of the provision, if you go through the Constitution, if any of the provision we feel is unnecessary, and if the answer to that question is no, then in my opinion, the fact that the Constitution is lengthy cannot be a criticism. And if we see the Constitution encompasses everything, we are a vast country dealing with diverse situations, diverse ethnicities, diverse religions. And if we see the Constitution, it takes care of all the aspects in the sense there is a provision for Northeast, there is provision for Kashmir, there is provision for Union Territories, there is provision for states, different type of states dealing with different type of ethnicity, different type of religions and different type of cultures. And all the aspects, namely, if we start from Article 1, the Constitution, the preamble, the citizenship, then the fundamental rights, then the directive principles of state policy. Thereafter comes fundamental duties, then the executives, thereafter the parliament, then the state executive, the state parliament, the state legislative assembly, then the finances under the state, the finances under the union. Thereafter we have the Union Public Service Commission, the public service commissions of the state. All the aspects which are required to be dealt with have been dealt in our Constitution. The second aspect which we often face criticism is number of amendments. We say that there are 106 amendments, normally criticized for having so many amendments. But barring certain amendments which are struck down by the Supreme Court being unconstitutional, looking at the diversity of the country, looking at the fact that when the Constitution was enacted in the year 1950, we were a very young nation and we had to go through so many social reforms over the years. The criticism that there are too many amendments is not a very well taken criticism. More particularly, almost I must say it's a credit to our parliamentarians that they were aware of the social requirements at that point of time and they came up with necessary amendments to the Constitution. So these are the basic two the criticism which we face as regards to Constitution is concerned. Today we are dealing with a topic. We have a keynote speaker here. I welcome you all. Now I request our President to give a welcome address to the gathering. Okay. First I request the dignitaries to take the leads. My Lord Justice Sarun Kopra, the Advocate General of State of Goa as well as State of Maharashtra, and our President. Request Simon to hand over the hampers to our distinguished guests. Justice Sarun. Devidas Fund Advocate General State of India. Our own President. Justice Valmiki. And Justice Now I request the President to deliver the welcome address.
Honorable Mr. Justice Sarang Kotwa, the Chief Guest of today's function, Honorable Mr. Justice Valmiki Iglesias, Honorable Mr. Justice Ashish Kavan, Honorable Mr. Justice Sriram Sisar, Learned Advocate General of the State of Maharashtra, and today's keynote speaker, Dr. Virendra Saraf, Learned Advocate General of State of Goa, Mr. Devidas Fund, my senior and junior colleagues at the bar, and the students of law who are present. At the outset, I must express my sincere thanks to the administrative judge, Honorable Mr. Justice Sarang Kotwa, for accepting our invitation to be the chief guest of today's function. Thank you, sir. And equally, thank his companion judges for gracing this occasion and joining us to celebrate this Constitution Day. In a special way, I must thank Dr. Virendra Saraf for being kind enough to lend his precious time to the Goa bar by promptly and without any ado accepting my invitation to share his knowledge with all of us here. I do not want to embark on any rhetorical prose and deprive you of an erudite lecture that will follow by an expert on Constitution, Dr. Virendra Saraf, but as a president of the bar, it is my duty and privilege to say a few words in celebration of this day. Today we are celebrating the 76th birthday of the Constitution of India. The Constitution has, as of today, withstood 76 summers and is today celebrating its 76th winter. The inclement weather and our storming monsoons which this country faced all over these years have not been able to destroy the Constitution. The foundation of our Constitution is the will of the people. In its meeting on the 13th December 1946, when the Constituent Assembly of India met for the first time, late Sri Pandit Jawaharlal Nehru, while moving the objective resolution, said, and I quote, "We have met here today because the strength of the people is behind us, and we shall go as far as the people, not of any party or group, but the people as a whole shall wish us to go. We should therefore always keep in mind the passions that lie in the hearts of the masses of the Indian people and try to fulfill them." That's how the Indian Constitution was born. Its base and foundation is the people's will, and that's how India has proclaimed an independent sovereign republic with a well-designed constitution for its future governance. The test of time has proved that the basic structure of the Constitution, the foundation which was laid when the Constitution was enacted as the Magna Carta of the country, had withstood the inclement weather created by political parties in power to trample and or sway the basic structure of the Constitution from time to time. But the Constitution, enacted to express and safeguard the will of the people, has remained inert and has been the pillar on which this country's sovereignty, integrity, and unity has all this while been resting. The edifice of the country and of its people has been resting as of today on the basic structure of the Constitution. The Constitution envisages the three limbs of government: the legislature, the executive, and the judiciary. And it has been designed to make these three limbs, which are interwoven, work within the framework of the Montesquieu theory of separation of powers. Our Constitution has been amended 106 times, as Mr. Datta said. Some of these amendments were meant to obliterate and or take away the basic structure of the Constitution. At times, the actions of the government have been targeted to violate the rights of citizens guaranteed under Part 3 of the Constitution. But India, as a nation, has survived because of its Constitution. Though Constitution was a document prepared and enacted by the Constituent Assembly, yet it expresses the will of the people. The harmony in which the three branches of the government work, as designed and enshrined in the Constitution, has allowed our country to remain united and to continue to be a federal democratic republic as enshrined in the Constitution, unlike many other countries that lack a stable constitutional foundation, like the Soviet Union that has since disintegrated. Many a time, legislations have been passed by the Parliament which trample on fundamental rights. The judiciary has acted as a timely arbiter right from the inception of the enactment of the Constitution. The first major test came almost immediately in 1950 in cases such as K.K. Gopalan versus State of Madras, Ramesh Kapar versus State of Madras, and Brij Bhushan versus State of Delhi. These early decisions examined the restrictions of liberty and free speech, marking the beginning of a judicial review in independent India. Then came the moment of 1967 in Golaknath versus State of Punjab, where the Supreme Court held that Parliament had no power to amend fundamental rights. This judgment fundamentally defined the relation between Parliament and the Constitution. Then comes the most defining decision in the history of our Republic, Keshav Bharati versus State of Kerala. Here the Supreme Court enunciated the basic structure doctrine, holding that although Parliament may amend the Constitution, it cannot alter its basic structure. This doctrine remains the backbone of our constitutional identity. In Indira Gandhi versus Raj Narayan, the then government sought to make elections of the President, Vice President, Prime Minister and Speaker of the Lok Sabha immune from the purview of judicial review by virtue of passing the 39th Amendment to the Constitution. The Honorable Supreme Court struck down the law as being violative of the basic structure. On another occasion, the Supreme Court rose to the occasion when the legislature passed the 42nd Constitutional Amendment, wherein the legislature attempted to reduce the power of the Supreme Court and High Courts to pronounce upon constitutional validity of a law. The judgment of Minerva Mills provided key clarifications on the interpretation of the basic structure doctrine. The court ruled that the power of Parliament to amend the Constitution is limited by the Constitution. Hence, Parliament cannot exercise its limited power to grant itself an unlimited power. Much later, in the case of Sudan Singh versus New Delhi Municipal Committee, reported in 1989 SCC 4-155, the Supreme Court pronounced on fundamental rights of citizens to carry on trade and business. As a fact, our Supreme Court, by these various judgments rendered, has proved to be the real sentinel of the country's sovereignty by safeguarding the rights of citizens on whom the will of the people have been expressed by the Constitution. As I am here, it may not be out of place to mention that citizens today, due to the complexity of issues and uncertainty that prevails in the world, with special reference to our country, I may say that citizens have a lot of hope and trust in the judiciary. And perhaps the trust which the citizen has in the judiciary makes him or her concerned about whether a judge will really follow Montesquieu or not. But as a citizen of this country, from the pronouncements thus far made by our constitutional courts, including our own high courts, which have risen to the occasion to unsettle laws which violate fundamental rights, I may with conviction say that the judiciary in the country, especially the constitutional courts, have not shirked their responsibility. By amendment to a chapter 4A of the Constitution, provisions were incorporated to enjoin upon the citizen the duties of a citizen, and they were incorporated by the 42nd Amendment. As Salmon puts it, duty is something owed by one person to another. Correspondingly, the latter has a right against the former. He further goes to say, to ascribe a right to one person is to imply that some other person is under a corresponding duty. As a fact, the law consists of certain types of rules regulating human conduct, and the types of rules regulating human conduct and administration of justice is concerned with enforcing the rights and duties created by such rules. In fact, to define right, it is necessary to define two other interconnected terms, namely a wrong and a duty. The existence of a fundamental rights, no doubt, carried with it intrinsically a fundamental duty. But after the 42nd Amendment, the same is enshrined in our Constitution. The topic which Dr. Saraf chose to address today, namely synthesis of fundamental rights and fundamental duties to realize constitutional goals, apparently, as the theme reads, relates to the right of a citizen to evaluate a wrong and observe its duty to uphold the obligation under the Constitution. As I do not want to get into and make any inroad into Dr. Saraf's speech, I would wind up by saying that we should relish and evaluate what Dr. Saraf is going to point out to continue to celebrate the birth of the Constitution in a true spirit, which we citizens should. Before I wind up, I must, as we are all gathered here, and due to the proximity of the event, I must take this opportunity to congratulate the Goa High Court Bar Association football team for winning the coveted Chief Justice M.C. Chadha Rolling Trophy Mumbai by defeating their adversary, the Bombay High Court Bar team. Please give the team a big applause. Thank you.
May I now call upon Advocate General State of Goa, Mr. Devdas Pandey, Senior Advocate, to address the people.
Good evening to all of you. Your Lordship Justice Kotwal, Lordship Justice Chauhan, my counterpart in Maharashtra, Advocate General of Maharashtra and a good friend of mine, Dr. Saraf, the President of the Goa High Court Bar Association, senior members of the bar. Welcome all of you. Friends, today we are celebrating the Constitution Day. On this day, the Constitution was signed by the members of the Constituent Assembly. Now, when we think about the members of the Constituent Assembly, we remember hardly few of them, maybe one or two of them. But we forget that there were more than hundreds of members of the Constituent Assembly who were instrumental in drafting this instrument called as Constitution. They were the ones who decided, discussed, and they worked hard. And I don't know how much they have worked hard. Unfortunately, they do not get the credit which is deserved by them. Today, everybody who is sitting here may not be knowing even 5 names of the members of their Constituent Assembly. That is unfortunate part of any system where the real people who are in the background and who have worked hard and who have actually did the work, they do not get the name or the fame. I think something should be done to bring forth the names of these people, and I am sure that in future our association or some other association would do this work and find out who are instrumental in coming out with such nice articles in the Constitution, who were the parts of the debate which took place in the Constituent Assembly. I was fortunate that during my early days of the profession, I was able to read the Constitution, the Constituent Assembly debates, and it is so fascinating. I must tell you, as colleagues at bar, and especially the students and youngsters who have joined the bar, you have some time now to read that book called as the Constituent Assembly Debates, and you will be amazed if you read it that what type of characters were these people who debated, discussed every word of the Constitution. You will be surprised that on every article, whether there should be a comma here or whether there should be some head note in a particular manner, whether it should be styled in a particular manner, there were debates continuously, and you will be, on that book you will find there will be debates of 5 pages, 4 pages on one phrase itself. And you will find a variety of debates. Now you can imagine that what type of debate took place in those discussions. Today you can't imagine what type of proposals were put forth. I can tell you one instance in that debate. The issue was about the official language of the country, of the national language. That was the issue. And I must tell you, the debate is so fascinating. And I must further tell you that the proposals were not that it should be Hindi or it should be English. The proposal started from whether it should be Sanskrit, whether it should be Tamil, whether it should be Bengali, whether it should be Sanskrit, or whether it should be even Urdu, or whether it should be Hindustani. There was a language before the advent of Hindi or Urdu. There was a language which was called as Hindustani, which was spoken in the north part of India. So thorough discussions. Every word was debated, the pros and cons, and finally there was a proper voting by virtue of which it was decided that one thing is it should be left to the states, that they will decide as far as their official languages are concerned, and as far as national language is concerned, they said it will be Hindi and English also will be used. But it is so fascinating. Every article was discussed, Article 14, Article 19, Article 21. It is really fascinating to read it. And it is not only fascinating, you will enjoy it, but in practice you will really be able to make use of it. You know the ideas, you know the objectives of enacting particular article. That is one part of the Constitution. Second part which you see from the Constitution Assembly debates is that the level of debates which took place in that assembly, it was amazing, I am telling you. I am sure that none of the debates in a parliament or in any assembly in the country would be as good as the debates which took place during that time. And you see the caliber of the persons who were the members of that Constituent Assembly. There was not even one person who was below postgraduate. Most of them were lawyers, they were barristers, but many of them were ICS officers. There were people who were PhD holders, and there I don't want to demean anybody, but they were so highly qualified, and they had thoughts for India for generations to come, hundreds of years to come, and thousands of years to come. And what we see as India and the success of this Constitution, unlike any other Constitution which were framed during the time when Indian Constitution was framed, which were failed, and they were thoroughly failed. And the best example of that is Sri Lankan Constitution, Pakistani Constitution. They have thoroughly failed. They were contemporaneous with Indian Constitution, but the Indian Constitution has stood the test of time. And the reason, if you ask me, is the members of the Constituent Assembly and the debates they did in that Constituent Assembly. So that was something fascinating. and I request the youngsters to please read this book. I don't know whether this book is available in our library. I think it should be available. Just go through and you know the people who were behind all this, which we call as the best constitution today. Now friends, I don't want to take much time of yours. The keynote speaker is the one who is going to speak about an important topic of fundamental rights vis-a-vis the fundamental duties. Now on this topic, there is, I think, hardly any discussion or debate as to what is the importance of fundamental duties. Now to me, although nobody speaks about the fundamental duties, everybody talks about the fundamental rights. People now have seen fundamental rights in everything. Anyway, that is the part of the system. But what are fundamental duties? Fundamental duties, although there are some which are mentioned in the Constitution and they are there, but to me, the fundamental duties are actually inborn in the fundamental rights. Now, one would ask how it is. The simple answer to that could be that if you say that the fundamental rights have to be honored and have to be respected and have to be implemented, and while doing so, you have to recognize that if every citizen has a fundamental right, then it is the duty of all other co-citizens, other citizens, to ensure that the fundamental right of that citizen is protected. And if you remember that duty to respect the fundamental right of each citizen, then I think there won't be any breach of fundamental right. So basically our fundamental rights are styled or are fashioned in such a manner that it casts a duty on all of us to ensure that the fundamental right of a citizen is not defeated. And if this duty we are able to perform, then we don't have to speak about the fundamental rights at all. So the prime importance about the fundamental rights is that it is the duty that is cast on the rest of the country to ensure that the fundamental right of one citizen is not defeated. So as we see that the fundamental rights which are mentioned in the Constitution may be illusionary or may be small, they are not given so much of respect. But as a matter of fact, the fundamental duties are most prominent in our Constitution, because when it is said that the fundamental rights of the citizens shall be protected in our country, that means there is a duty which is enjoined on the rest of the citizens to ensure that a fundamental right of one citizen is protected. So therefore, to me, fundamental rights and fundamental duties are actually sides of one coin. And if you respect the fundamental rights of every citizen, then you naturally tend to fulfill your fundamental right. That is what I feel about the fundamental rights and the fundamental duties. But today, we have an able speaker who is a good friend of mine, and I must say that the Advocate General of Maharashtra is a person who is really down to earth. I have interacted with him. He is the simplest of the men, but he is a great person. He is a knowledgeable person and the most competent lawyer. I respect him for his knowledge, but more than that, I respect him for his simplicity. We are privileged to have him here, and we are grateful to him for acceding to our request and coming down all the way. Although it is a working day in Bombay, he took time specially for this purpose, and he is there with us. Thank you so much, sir, and thank you.
Today we have amongst us our chief guest, Justice Sarang Kotwal. He did his schooling from Gule. He comes from a engineering background, science background. So when we see him at the bench, the clarity and brevity that flows from there. Thereafter he completed his LLB degree and enrolled as the advocate in the year 1992. Thereafter, in the year 2017, he was elevated as the judge of the High Court of Bombay. And today he is amongst us. I request him to give you an address.
My elder brother, Justice Sawan, Justice Shiv start. Honorable Advocate General, our Advocate General now I must say, of Goa, our esteemed guest today, Dr. Saraf, President of the Bar, Mr. Pereira, all the committee members, senior advocates and friends. This is the first time I'm having some interaction with the bar as a whole, and I'm very thankful to the committee for inviting me for this function. And you could not have chosen a more auspicious day for this interaction, the Constitution Day. We celebrate three important dates for our country. Obviously, the Independence Day, the Republic Day, and now the Constitution Day. For the first 2 days, we salute our flags, then we have our functions. This is a day where we salute our Constitution, but merely we are offering floral tributes is not sufficient. If we really want to honor our Constitution, we have to live by it and we have to follow all the ideals and whatever it provides for us. Then it would be a real tribute or our contribution to following the constitutional ideals. As far as Constitution is concerned, it's a very intriguing document. You see, all the common man, common people in the society, they live by Constitution without knowing that the Constitution is protecting them. They are living in this free world, they are professing their profession, they are having all the opportunities, they are
liberty, justice, and fraternity. Equality. The preamble really sets out the objectives which the Constitution aims to achieve. And if you see every part of the Constitution, you will be able to relate it to one of these ideals in the preamble. Try it. Any part of the Constitution you pick up, you will be able to relate it to some of the ideals which are set out in the preamble. And particularly in the Constitution, these ideals are sought to be achieved by the trinity of Part 3, setting out fundamental rights, Part 4, setting out directive principles, and Part 4A, setting out the fundamental duties. Now, Part 3 really sets out the inalienable, as we say, the inviolable natural rights of a citizens, which we all call fundamental rights, and as the Constitution calls it in Part 3, the fundamental rights of a citizen. And each of these fundamental rights, which the Constitution acknowledges, is towards the fulfillment of one of the goals, one of the ideals set out in the preamble. So when Article 14 to 16 gives a citizen a right to equality, the concept of equality and justice set out in the preamble is furthered. When Article 14 ensures that a person shall not be denied equality before the law and equal protection before the law, Article 15 prohibits discrimination on the ground of religion, race, caste, sex, or place of birth. Article 16 ensures right to equality and opportunity in public employment, and Article 17 seeks to prohibit untouchability. What are these but aspects of equality and social justice set out in the preamble? Similarly, the Article 20, when Article 19 speaks of freedom of speech, a right to assemble, a right to form associations, these are all liberty of thought and expression set out in the preamble. When Article 26 to 30 provide for freedom of conscience and freedom of profession, practice, and propagation of religion, the freedom to manage religious affairs, the same clearly advance the concept of liberty of thought, belief, and worship set out in the preamble. Article 21 and 22, of course, further the ideal of liberty in the preamble. So each of the fundamental rights are relatable and intended to achieve one of the goals set out in the preamble. Now, the Constitution of India has not been a static document, it's been a transformative document. And that is the vision of the founders, where the Constitution was made in such a way that it could adapt with times, with changing times. And the courts have stepped in to give an interpretation to the constitutional provisions to meet the changing times. And in recent times, various fundamental rights have been expanded to meet an evolving society. Right to privacy is treated now as a part of right to life. The provision relating to the criminality of consensual sex between people of the same sex was held to be unconstitutional and violative of fundamental rights. The provision of criminal law regarding adultery was held to be violative of a right of equality and a dignity of a woman. So our constitution has evolved from time to time. And equally, the courts have zealously safeguarded the fundamental rights. There were various attempts to entrench upon fundamental rights. And as Mr. Pereira pointed out, from time to time the courts stepped in. The citizens were vigilant to approach the courts. First of all, the citizens were conscious of their rights and approached the courts, and the courts stepped in, at times changed course, corrected their past errors, and set right things in a manner that the fundamental rights of a citizen become inviolable, inalienable. As Mr. Pereira pointed out, the earlier view in A.K. Gopalan and Satwant Singh, which said that fundamental rights operate in different silos, and once if a requirement of fundamental right is complied with, it cannot be subjected to the test of another fundamental right. That was set right in Maneka Gandhi, which said that they are part of an integrated scheme. So when the procedure established by law under Article 21 is framed by the government, it still has to undergo the test of Article 14. It has to be a fair procedure. It has to be a just procedure, not just provision of a procedure. So all the fundamental rights were held to be a part of an integrated scheme. Similarly, the courts stepped in to say that there can never be an abrogation, complete abrogation of fundamental rights. The unlimited right to amend the Constitution without a scrutiny of the court, which was earlier the view in Shankari Prasad and Sajjan Singh, was set right in Golaknath, and that led finally to Keshwananda Bharati, the basic structure doctrine, Minerva Mills, the Coelho judgment, and even the statutes which were put in 9th schedule were subjected to a certain scrutiny. So therefore, we are all very conscious of our fundamental rights. We every day are assertive of our fundamental rights, and at times citizens have stood up for the rights of others. Now this is part 3, and I have related part 3 to the different ideals of the Constitution set out in the preamble. The next chapter is part 4, that is directive principles of state policy, which are essentially the principles which are fundamental in the governance of the country. The Constitution says that they are not enforceable, but they are fundamental in the governance of the country. And if you see these directive principles similarly, as I said, please do this exercise. I'm not going to do today every bit because it will take time. But if you take each of these directive principles, you will be able to relate it to one of the ideals in the preamble. What I want to show is that part 3, part 4, and part 4a are a part of a common scheme of things, each of them trying to advance the constitutional ideals and goals set out in the preamble. So when the directive principles state that the state shall strive to promote the welfare of people by securing and protecting a social order in which justice, social, economic, and political shall inform all institutions of national life, it is clearly the obligation of the state to advance the goals set out in the preamble. When Article 38 and 39 provide that the state shall minimize certain inequalities and ensure equal justice and free legal aid, the various concepts of the preamble are advanced. So each of the directive principles you will be able to relate to one of the principles. But rights are subject to restrictions. Each of the fundamental rights say that there are situations in which reasonable restrictions can be put on the fundamental rights. That is because ultimately we do not live in isolation. And sometimes, for the common good, the curtailment of an individual right becomes necessary. And therefore, the courts have said that it is important to read fundamental rights and directive principles together. In Minerva Mill, also, the Supreme Court highlighted that there needs to be a balance between the two. Because when you are seeing the reasonableness of a restriction on a fundamental right, you see that is the state trying to promote common good by trying to do something which can be related to the directive principles of state policy. So, a reasonableness of a restriction on a fundamental right, the attempt to give directive principles a higher status than fundamental right was set aside by the Supreme Court. But yet, time and again, the Supreme Court has said that we need to read fundamental rights with directive principles, because in reading the directive principles, we will understand what is the endeavor of the state to promote the common good, public order. In different provisions, you will find the different words. Somewhere it is public order, somewhere you will find morality, public morality. So these are aspects from which assistance can be taken from directive principles. Equally, the courts have read the directive principles to expand fundamental rights also, because the courts have said if this is an obligation of the state to perform, then it is of course a part of one of the rights. So while interpreting various fundamental rights of citizens, the courts have taken resort to directive principles, and with time they have read various aspects like free legal aid as a part of Article 21 and various aspects, and you will see in series of judgments where the courts have looked at fundamental at directive principles while interpreting fundamental rights. Now, is the furthering of the constitutional goals only the responsibility of the state or the judiciary? Because fundamental rights are enforceable against a state. Directive principles are an obligation, or rather, what is expected of a state to do in the course of governance. So, is it only their responsibility, or do we as citizens also have a responsibility to further the constitutional ideals which are set out in the preamble and the entirety of the scheme of the Constitution? Is there a disproportionate emphasis on the rights of citizens as against duties? Now, if we go to our Indian society, the historic society, there has always been an emphasis on duties. There is a concept of kartavya. There is a concept of you do your karma and then leave the fruits to someone else. In every religion, in every society, you will find that there was an emphasis on what is a duty of every person. Have we over time lost sight of our duties and focused only on rights and entitlements? Actually, a right, fundamental right, is not an entitlement. It is your natural right. But is it that we are only asserting rights, forgetting our duties? And in this context, I would like to read a passage, a quotation of what Mahatma Gandhi had said much before the Constitution got framed. He said that the true source of right is duty. If we all discharge our duties, rights will not be far to seek. If leaving duties performed, we run after rights, they will escape us like the will o' the wisp. The more we pursue them, the further they will fly. He said, I learned from my illiterate but wise mother that all rights to be deserved and preserved come from a duty well done. Thus, the very right to live accrues to us when we do the duty of citizenship of the world. From this one fundamental statement, perhaps it is easy enough to define duties of men and women and correlate every right to some corresponding duty to be first performed. So, this was the father of the nation saying much before the Constitution was even framed. Even the Universal Declaration of Human Rights Article 29(1) in 1948 stated that everyone has duties to the community in which alone the free and full development of his personality is possible. So, this is the Universal Declaration of Human Rights in 1948. But our Constitution, as framed originally, did not have any chapter or provision regarding fundamental duties. And I wondered why. I could think that maybe the framers of the Constitution were people who had dedicated their lives in the freedom struggle. For them, it was all about contribution to the nation. And this spirit of nationality, the spirit of giving, was so deeply entrenched in them that they thought and expected that this is the sentiment which should be there in every citizen, every person. The other way of thinking it is that it is possible that they thought that when they set out in the preamble the goals, and it is the citizens who, when we say we give ourselves this constitution, this is expected of the citizens that they will do everything for the success of the constitution. And therefore, it is possible that the expectation was that whatever is needed to achieve these goals is obviously the duty of every citizen to perform. And the third way of thinking it is that it was felt that the rights enshrined in Part 3 on fundamental rights have inbuilt obligations thereon. So, this is a possible thought process which is never crystallized anywhere, which at the beginning of the Constitution, why no fundamental duties were provided. But much before the Constitution incorporated Chapter 4A in the Constitution setting out fundamental duties, in 1969, the Supreme Court was dealing with a case regarding payment of minimum wages. And the question was to strike a balance between should not a worker be paid a minimum wage, an amount which will help him survive, and on the other hand, will the fixing of the minimum wage result in the industry or the unit being killed, taking away the right of the owner to exist? The court held that freedom of trade does not mean freedom to exploit, nor do provisions of the Constitution barriers to progress. They provide a balance for orderly progress towards social order contemplated by the preamble of the Constitution. And this is in 1969, much before the bringing in of the chapter on fundamental duties, the Supreme Court said it is a fallacy to think that under our constitution there are only rights and no duties. While rights conferred under Part 3 are fundamental, the directives under Part 4 are fundamental in the governance of the country. We see no conflict in the whole between the provisions of Part 3 and Part 4. They are complementary and supplementary to each other. The provisions of Part 4 enable the legislature and the government to impose various duties on the citizens. So what the court said is that when laws are enacted in furtherance of the directive principles of state policy, they are in fact imposing duties to be performed by citizens. Now, there are various laws which ask us not to do certain things. We have a law called Scheduled Caste, Scheduled Tribe Atrocities Act. Now, that is an act which says if you do something like this, you will be punished. That is seeking to enforce a duty of yours otherwise also, to treat all your fellow citizens with dignity, to treat everyone with equality. Now, therefore, the Supreme Court said that directive principles of state policies empower the state to enact various laws, to impose duties on citizens. But the question which I'm here to ask myself and all of you today is, do we need laws to ask us to perform our duties? Or should we be conscious of our own duties and perform it as citizens to further the constitutional goal? If we dream to live in a particular world, are we contributing towards creation of that world? And do we require laws to tell us, you must do this? Now, what I would like to, the Part 4A was then brought in by the 42nd Amendment to the Constitution in 1976. There was a Swaran Singh committee which went into various constitutions of the world, including that of Japan, etc., and brought in Part 4A. Now, what is common between Part 3, Part 4, and Part 4A is each one of them uses the word fundamental. Though Part 4 and 4A may not be enforceable, but they still say that Part 4 says these are fundamental principles of governance, and Part 4A calls it fundamental duties. And therefore, a common thread runs through Part 3, Part 4, and Part 4A. Fundamental duties are in the nature of a mixed bag of expectation and exhortation to the citizens. When Article 51A expects a citizen to abide by the principles of the Constitution, it expects citizens to abide by the ideals set out in the preamble. If the fundamental rights are in furtherance of constitutional objectives set out in the preamble, it is equally the duty of the citizens that they do not trample upon the rights of the fellow citizens. When the preamble speaks of equality and fraternity, there is an expectation in Article 51A that citizens will promote harmony and spirit of brotherhood amongst all the people of India, transcending religious, linguistic, sectional diversity, and therefore this is now expressly mentioned in Article 51AE. So what is this? This is advancing fraternity. This is respecting the rights of others. This is respecting the concept of liberty and fraternity set out in the preamble. So each of the fundamental duties, if you see, it will be relatable to one of the fundamental rights in Part 3. Equally, it will be relatable to one of the ideals of equality, justice, liberty, and fraternity set out and the preamble. So please do this exercise. The courts have time and again done it in various cases. Now, the fundamental duty to protect the dignity of a woman is nothing but an expectation from the citizen to abide by the objective of equality. The expectation from a citizen to improve the environment It is an aspect of respecting the right to life and liberty of every citizen to live in a clean environment. Now, I'll just mention a few judgments of the Supreme Court in this context. I'm not going to be elaborate in my judgments because you all can go it. In Ram Leela Maidan case in Supreme Court, there was a big gathering of people in the Ram Leela Maidan of Delhi, and it was initiated for some protest, and thereafter things went out of hand. The facts are not relevant, and the Supreme Court suo motu took cognizance of that incident. And in that matter, the Supreme Court, while emphasizing the freedom of expression, freedom of speech of a citizen, the freedom of a citizen to assemble under Article 19, emphasized that these rights are subject to reasonable restrictions as set out in Article 19. But equally in this judgment, the Supreme Court emphasized that it is equally the duty of the citizen who seeks to exercise that right to abide by the Constitution, to promote harmony, to safeguard public property, and to abjure violence. And the Supreme Court said, while you have rights, please exercise it, but don't forget your own duties which you have. And in this case, the Supreme Court said that there has to be a balance and proportionality between the right and the restriction on the one hand and the right and duty on the other. It will create an imbalance if undue or disproportionate emphasis is placed upon the right of a citizen without considering the significance of the duty. And these are words of the Supreme Court. The true source of right is duty. When you assert your right, you must respect the freedom of others. Every right has a corresponding duty. When the courts are called upon to examine the reasonableness of a legislative restriction on exercise of a freedom, the fundamental duties enunciated under Article 51A are of relevant consideration. Article 51A requires the individual to abide by the law, to safeguard public property, and to abjure violence. It also requires the individual to uphold and protect the sovereignty, unity, and integrity of the country. All these duties are not insignificant. So the Supreme Court said that when I'm considering the reasonableness of a restriction on your right, I'm also going to see what your duties are. And if I find that the restriction is something which is seeking to ensure that you perform your duty, which is expected of you under the Constitution, then that restriction cannot be said to be unreasonable. Thus, all these duties are of constitutional significance, the Supreme Court said. It is obvious that the Parliament realized the need for inserting the fundamental duties as part of the Indian Constitution and required every citizen of India to adhere to these duties. Thus, it will be difficult for any court to exclude from its consideration any of the above mentioned articles of the Constitution while examining the validity of restriction placed on fundamental rights. And therefore, the Supreme Court came down and relied upon fundamental duties while testing the reasonableness of restrictions placed on fundamental rights, because they are, after all, two sides of the same coin, as the learned Advocate General said. Now, there are series of judgments. In AIM Students Union case, the Supreme Court was considering a situation where in AIMS, 33% seats were reserved for in-house candidates. And the Supreme Court said that it is the fundamental duty of every citizen to strive for excellence and to rise to higher level of endeavor and achievement. And by putting such a restriction, you are curtailing that ability of a citizen to perform this fundamental duty. So here, the Supreme Court uses a fundamental duty of a citizen to set aside a restriction and say that this is depriving a citizen of his right to do, of his duty to do something. And here, the Supreme Court said something very different. It said that the fundamental duty of every citizen is collectively the duty of the state. So the Supreme Court had, though, one line in that judgment, I found it very telling. It said that if it is a duty of every citizen of this country, then collectively it is also the duty of the state to promote excellence, to ensure that everybody gets an opportunity to reach to higher level of achievement. Now, Supreme Court in this case said that fundamental duties, though not enforceable by a writ of court, yet provide a valuable guide and aid to interpretation of constitutional and legal issues. In case of doubt or choice, people's wish as manifested through Article 51A can serve as a guide not only for resolving the issue, but also for constructing or molding the relief to be given by courts. So I'll close in 5-10 minutes. How long? Take some time. Now, one more judgment which is important is the judgment in the case of Subramaniam Swamy, where the provision in criminal law relating to defamation was challenged. The constitutionality of the provision in criminal law making defamation an offense was challenged. Now, in that judgment, once again, the Supreme Court laid great emphasis on the fundamental duty of citizens and said that fraternity is a constitutional value which is to be cultivated by the people themselves as part of their social behavior. The court held that the concept of fraternity under the Constitution expects every citizen to respect the dignity of the other. Mutual respect is the fulcrum of fraternity that assures dignity. So therefore, do we require a mandate of a statute to tell us to conduct ourselves in a manner which will promote fraternity? It really does not. But the provision for defamation really is a deterrent to ensure that the citizen does not behave in a manner which is contrary to the spirit of fraternity. One has a right to freedom of speech and expression, the Supreme Court said. One is also required to maintain the constitutional value which is embedded in the idea of fraternity that assures the dignity of the individual. So while you have a freedom of speech, you cannot utilize it in a manner which will defeat the dignity of your fellow citizen. One is obliged under the Constitution to promote the idea of fraternity. Now, therefore, the Supreme Court said that individual interest of each individual serves the collective interest. It is subservient somewhere to the collective interest, and correspondingly, the collective interest enhances individual excellence. Action against the state is different than an action taken by one citizen against the other. The constitutional value helps in structuring the individual as well as community interest. Now, the Supreme Court finally, as I said that the preamble balances different and divergent rights. Keeping in view the constitutional value, the legislature has not repealed 499 and kept the same alive as a criminal offense. So what is it? You have a freedom of speech and expression. Do you have a right to exercise it in such a manner that will defeat or hurt the dignity of your fellow citizen, which will defeat the spirit of fraternity in the society? And if not, then we should not lead to a situation that a statute has to punish us for doing that. It's a fundamental duty, as we expect the state to come and not disturb our fundamental right. Why do we want the state to come and force us, compel us to do our fundamental duty? That should now become somewhere our natural sentiment. Now, there are a series of judgments, particularly in relation to environmental law. The Supreme Court evolved and relied extensively on fundamental duties. There are judgments in the case of Rural and Litigation and Entitlement Kendra, where Justice Ranganath Mishra, as the Chief Justice of India, I just want to mention this judgment because Justice Ranganath Mishra then wrote a letter to the Supreme Court, which was treated as a suo motu PIL by the Supreme Court in the context of fundamental duties. Now, in the case of Rural Litigation and Entitlement Kendra, the Supreme Court, Justice Ranganath Mishra, was dealing with a situation where their limestone quarries were affecting the environment, and the Supreme Court directed that the licenses of these quarries be cancelled. Now, in that matter, Justice Mishra, Ranganath Mishra was then the Chief Justice, observed that preservation of the environment and keeping the ecological balance unaffected is a task which not only the government but also every citizen must undertake. It is a social obligation, and let us remind every Indian citizen that it is his fundamental duty as enshrined under Article 51 AG of the Constitution, assigning paramount significance to fundamental duties and rather placing the fundamental duties owing to the people at large above the fundamental rights of a few individuals. The court held that this closure would undoubtedly cause hardship, but it said that it is a price that has to be paid for protecting and safeguarding the right of people to live in healthy environment with minimum disturbance of ecological balance and without avoidable hazard to them. So when you have a right of freedom to do business, it is also your duty to see that your fundamental duty to protect the environment is not defeated, and that you can do it on your own. You could be guarded on your own, or you could defeat it and then wait for the enforcement persons to come and enforce it to you. That is what I'm here to discuss with you all today. That do we require enforcement of fundamental duties by the state by framing of statutes? That should become a natural spirit. Now, as I said, there are series of judgments, the precautionary principle, the polluter pays, all these principles were evolved by the Supreme Court, and the Supreme Court in these judgments did refer to the fundamental duty of the citizens. In Sachidanand Pandey, in LiveLaw Citizens Welfare Association, various cases relating to environment. And therefore, in MC Mehta versus Union of India, the Supreme Court particularly issued directions consistently with Article 51A, saying that in various educational institutions, there should be teaching and they should be taught about protection of environment and how there should be textbooks written for the said purpose and distributed to educational institutions so that children from a very early age are conscious of their duty towards the environment. And in MC Mehta, great detailed directions were given as to how this duty of protecting the environment should be inculcated in citizens from a very early age. Later, the central government formed a Justice Verma committee to go and give a report on how the fundamental duties can be developed as a package for teaching at primary, secondary, senior secondary, and university levels. And they wanted a great detailed report, how to operationalize the suggestions to teach fundamental duties to the citizens of India. Justice Verma committee gave a detailed report of how to bring about awareness and how to teach, how to inculcate the spirit of fundamental duties amongst the citizens from a very early age. And just one para of this report I'll read for you. It said that the most important task before us is to reconcile the claims of individual citizens and those of a civic society. To achieve this, it is important to orient individual citizens to be conscious of his social and citizenship responsibilities and so shape the society that we all become solicitous and considerate of the inalienable rights of our fellow citizens. Therefore, awareness of our citizenship duties is as important as awareness of our rights. Every right implies a corresponding duty, but every duty does not imply a corresponding right. Man does not live for himself alone. He lives for the good of others as well as of himself. It is this knowledge of what is right and wrong that makes a man responsible to himself and to the society, and this knowledge is inculcated by imbibing and clearly understanding one's citizenship duties. The fundamental duties are the foundations of human dignity and national character. If every citizen performs his duties irrespective of consideration of caste, creed, color, and language, most of the malaise of the present day polity could be contained, if not eradicated, and the society as a whole uplifted. So this was what the Verma committee said, and I find these words so apt, that if every citizen performs his fundamental duty, then the cases of breach of fundamental rights will be minimized. Because when I talk of citizen, I do not only talk of one of us, because every person who is governing, who is in administration, is equally a citizen of India. And therefore, the Supreme Court, in one of the judgments, said that an administrator, a person who is in administration, is first a citizen of India, and therefore it is equally expected of the person in administration to remember his fundamental duty as a citizen. And if each one of us were to do our fundamental duties in this manner, then the chances of defeating one another's fundamental rights would be minimized. The occasions of that being defeated will be very few. Now, Justice Ranganath Mishra, as I said later on, wrote a very strong letter to the Supreme Court saying that our society has forgotten their duties and we should take steps to spread consciousness about fundamental duties. The Supreme Court took cognizance of that letter, but at the hearing of the matter, Justice Verma committee report was placed before the Supreme Court and said that the central government intends to further and to act upon this report and to take steps for bringing about awareness of fundamental duties. The Supreme Court recorded that statement and disposed of that petition. Now, as I said, we could go on and on, but time is short. So I will close by saying a few things and sharing a few thoughts with you all. Baba Saheb Ambedkar said that independence is no doubt a matter of joy. But let us not forget that this independence has thrown to us great responsibilities, because by independence, we have lost the excuse of blaming the British for everything going wrong. If hereafter things go wrong, we will have nobody to blame except ourselves. And that ourselves is not only the persons governing, but each one of us. If things go wrong, who is to be blamed? Each one of us. And therefore, in conclusion, I would say that while we value our rights, and it is important that we cherish and value our rights and zealously protect our rights, it is also very important that we realize that we do not trample upon the rights of our fellow citizens. If each one of us respects the rights of others, it is only then we can collectively fight any attempt to entrench upon our rights. The duty of introspection demands honesty. Have we upheld constitutional morality in our public life? Have we understood our fundamental duties with the same seriousness with which we assert our fundamental rights? In an era of social media, which gives us a platform for free expression of our thoughts and ideas, it is important that we are equally responsible in our expression. While exercising our freedom of speech, we need to realize that our freedom is exercised in a manner which will not defeat the spirit of harmony and fraternity. And criticism is a very important tool to improvement. It is very necessary that every citizen is conscious, is aware, and has the right to criticize our institutions, whether they are the administration, whether they are the judiciary. But the right to criticism should be exercised in a constructive manner to build institutions, not to destroy them. For example, we are lawyers here, When one disagrees with a decision of a court, you are free to criticize it. You can say that the judgment has decided a point of law incorrectly. But when a person criticizes a judgment by assigning motives to a judge, just because the judgment does not align with his sense of justice, then that is trying to defeat an institution, and that is not a fair exercise of our fundamental rights of expression. Because I always believe that criticism should be guided with hope and desire to improve, not by despair and the urge to destruct. And therefore, each of our rights, when we exercise, we should do it in a manner which will help build institutions that govern, whether it is the executive, whether it's the legislature, and whether it is the judiciary. Please criticize, please find where what is going wrong and bring it to the notice of the whole of the nation, but do it in a responsible manner. As lawyers, we should not forget that apart from our role as lawyers representing the cause of our client, we also have duties as citizens to make our representations in a fair manner, to promote conciliation, to ensure that we aid the delivery of justice, which is the foundation of our society. As lawyers, we wield a certain control over the thoughts of a society, and we can play a very important role in spreading awareness about the constitutional ideals and the duty of every person to fulfill those ideals. Just to close, I will say that John F. Kennedy had said, "Ask not what your country can do for you, ask what you can do for your country." I will just alter it a little to say, cherish what this country has done for you, treasure the rights that you enjoy, vigilantly safeguard them, but remember equally the duties you owe to the country and your fellow citizen, because in our collective progress lies our individual well-being. Once again, I would like to thank the Goa Bar Association for inviting me. Thank you very much.
So thank you so much for our enlightening speech. You have nicely explained the relationship between the fundamental rights, the fundamental duties, and the directive principles of state policy. So we are truly obliged. One of the how the fundamental rights and fundamental duties go hand in hand is evident from the 86th Amendment, wherein Article 21A was introduced, whereunder the right of education was made a fundamental right. And if you see fundamental duties, at the same time, Article 51A was amended and a new clause was added, whereunder the duties of the parents or guardians, there was a duty cast on parent and guardian to educate the child between the age of 6 to 14. So this is how the fundamental rights and duties go hand in hand. Now, sir, the audience is saying that it is their right to ask questions, and I request you to perform your duty of answering them. So you can sit there. We will have a
So sometimes they need a warm-up question. Can I ask a warm-up question?
Please.
So there is a very nice article in today's Times of India wherein they've actually referred to and articulated how Supreme Court has expanded beyond textual interpretation the fundamental rights as defined in the Constitution in the context of the directive principles, and they've indirectly enforced directive principles by giving a very expensive interpretation of fundamental rights That's how social rights come in. So you've very nicely elucidated on how fundamental duties have been imported. If I may ask you a question, so do you think Supreme Court has done enough, or looking at the vastness of the nation and the diversity, possibly there could be something more that we can bring in to make it, I won't say to condition the fundamental rights, but in some way make it indirectly enforceable, considering the state of affairs today?
Why do we require a constitutional amendment to make a fundamental duty enforceable? As I said, the state in different manners ensures that a citizen performs his fundamental duties. When the state places restriction on a citizen from exercising some of his fundamental rights, it is to some extent an enforcement of a fundamental duty of the citizen. So when you do business and you are told that you must get an environmental clearance, that you should not develop in an eco-sensitive zone, carrying out certain activities in an eco-sensitive zone, that is why placing a restriction on your fundamental right to do business is indirectly enforcing your fundamental duty towards the environment. So we cannot, as somebody had said in the opening, that we have a very long, the length of a constitution is very long. And when Baba Saheb Ambedkar was asked why, he had said that because India, constitutional morality is not something which has seeped into Indian behavior till now. And therefore, if we were to, as citizens, act with constitutional ideals, some things have to be left in a manner that the citizens themselves exercise it. And indirectly, as I said, by various laws, various statutes, when defamation is made a crime, it is in effect enforcing a fundamental duty of a citizen not to speak in such a manner which affects the honor of someone else, which affects the dignity of someone else. So that is an indirect manner of enforcing a fundamental duty. But the Constitution cannot have a situation where one citizen keeps filing cases against others. In fact, we do. When you file a civil suit for a certain tort, you are in effect, one citizen is saying, please ask the other citizen to behave in a manner which is consistent with his fundamental duty. You may call it a suit to enforce your right, but if you look at it another way, it is also a suit to enforce the duty of the other person. I think it's a late evening, so people are exhausted. Let's call it a day. Anything else? All right. Chalo. Thank you.
I believe nobody wants to enforce their rights, but nevertheless, it's now to a small gesture from our side and a token of appreciation for the guests who are here. May I request Simon to present token of appreciation to Justice Sarang Kotwal. Sorry, the President to present. I also request the President to present a small token of appreciation to Dr. Biren Saraf. Now it's time to propose the vote of thanks. I request Prashil Arolkar to please propose the vote of thanks.
Respected Chief Guest, Honorable Justice Sri Sarang Kotwal, esteemed keynote speaker Dr. Birendra Saraf, Learned Advocate General for the State of Maharashtra, Honorable Justice Ashish Chauhan, and Honorable Justice Sri Sriram Sirsat, and Advocate General for the State of Goa, Sri Mr. Devidas Pangam, my fellow members, senior members of the bar, distinguished guests, students, ladies and gentlemen, on behalf of the Goa High Court Bar Association, it is my profound privilege to propose the vote of thanks on this auspicious occasion of the National Law Day, as we gather to reaffirm our commitment to the rule of law and the sanctity of our Constitution. First and foremost, we extend our deepest gratitude to our chief guest, Honorable Justice Kotwal, for gracing us with your august presence and for your enlightening address. Your honor's words have not only inspired us but also reminded us of the judiciary's pivotal role in upholding justice with compassion and integrity. We are equally honored by the presence of Honorable Justice Valmiki Vinizes, Justice Chauhan, Justice Sirsat, who have graced this function. We offer our sincere appreciation to our keynote speaker, Dr. Birendra Saraf. Your insightful address on the topic was truly enlightening and thought-provoking. Sir, your deep knowledge and clear explanation of the important balance between rights and duties have greatly impressed all of us. This kind of thoughtful discussions truly respects the ideas of those who wrote our constitution and motivates us to work towards a fairer and more responsible society. We also thank Senior Advocate Sri Devidas Pangam, Learned Advocate General for the State of Goa, for providing his valuable insights on the Constitutional Assembly debates. I must also thank our President, Senior Advocate Mr. Coelho Pereira, for his vision, guidance, and welcome address, and my fellow committee members of the association for their tireless efforts in organizing this function. Finally, our heartfelt appreciation goes to all the senior members and the advocates, also the students who have attended and participated in today's function to celebrate the National Law Day. National Law Day is not just a ceremony to remember something from the past. It is a strong reminder to every citizen and every lawyer that we must always keep fundamental rights and fundamental duties at the center of our daily lives. Let us leave this place today with a fresh promise in our hearts to follow the Constitution fully, both by its words and its true spirit. With these words, I conclude our proceedings of this memorable function. Thank you.
There's a small announcement to make. From January onwards, the Goa High Court Bar Association would be coming up with a journal whereunder the latest judgments of our High Court will be published. Advocate Raghunandan would be in charge of that. So the modalities and all those things will come little later, but this is just an announcement. So I request you all to avail of this facility. We will make it public thereafter. Now, I request everybody to please stand up for the national anthem. Nandini from
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाहे तब जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जय हिंद।
What a wonderful lecture, and we are very less to say. We would love to have you in our institution at some point of time. Sir, very recently now, in December, we are about to have a conference where Justice Surikant will be addressing the occasion. Yes, sir. Definitely, sir. We'll come. Yes, sir. Yes. Ms. Sanya, Faculty of Law, Mr. Director, Ms. Shani.
I will coordinate with the member of the Council.
Yes.